guys, this is Asa and I'm studying for the bar and I wanted to review some of my notes with you. So today I'm studying professional responsibility. Of course, this isn't my outline and this isn't my notes necessarily, but the book was laying around and I wanted to have something in my hand to show you. So, professional responsibility book and subject that I'm studying. So today I'll be studying the scope, objective, and means of representation. So what do I mean by that? I'm going to talk about means of handling a conflict and the traditional and the limited scope. First of all, the Model Rule of Professional Conduct 1.2a states that a lawyer shall abide by a client's decision concerning the objective of the representation. So the lawyer must listen to the client's objective of what the client wants, even if that's not what the lawyer wants. He has to listen, even if he thinks that's wrong and he could get a better result, or he thinks that the client doesn't know. But if that's what the client decides, that's what it'll be. So a lawyer shall abide by a client's decision concerning the objectives of the representation. Rule 1.2a. The next thing I want to talk about is limited scope. So lawyers have actually significant latitude to limit the representation of the client. What do I mean by that? There might be a reasonable circumstance where the client is informed and gives informed consent. Then in that circumstance, the lawyer may limit the representation. But it's very important that the client gives informed consent. So what do I mean by that? I mean that the client must know the consequences of the action. So let's say that the lawyer is really deep in the case, and if he suddenly bails on the client, that will significantly affect the outcome of the case. So the client, he might be so busy in his life and he might not understand because, the client isn't the lawyer, doesn't have the knowledge. So the client might suddenly give an informed consent. It might seem informed, but it might actually not be informed because they don't understand the consequences. So that's very important. So what I'm trying to say is that the lawyer just can't bail on the client. But there are sometimes that the lawyer can be like, okay, I'm done working for you. But also he cannot just bail when they're so deep in the case. The next thing I would like to talk about is Model Rules of Professional Conduct 1.2a. So this rule states that a lawyer may take such action on behalf of the client as is implied, authorized to carry out the representation. So that's very important. So the lawyer may act when there is an implied authorization. So what do I mean by that? So there's some special circumstances where the client might actually be diminished in capacity. For example, the client may be some sort of a minor or some sort of a mentally disabled person who cannot actually decide at that point and cannot adequately consider a decision. So in this case, the lawyer has a little bit more power because it's a special circumstance. And also, when there is a substantial physical, financial, or some other harm that it cannot adequately protect the interest and take necessary protective action. And then the next thing I would like to talk about is criminal or fraudulent acts. So, no counseling or assisting for criminal or fraudulent acts. And this must discuss the legal consequences. So it's okay if, the client comes and then says, let's do something fraudulent or criminal, and then the lawyer actually discusses the legal consequences. That's okay. But, they cannot get involved. And then the next thing I would like to talk about is terminating the relationship. So let's say that an attorney-client relationship is formed and suddenly the lawyer wants to terminate the relationship or the client wants to terminate the relationship. So how does that happen? So termination is required when the client wants illegal and unethical conduct. So this is required actually by the lawyer to terminate when the client wants illegal and unethical conduct, or if the lawyer is physically and mentally unfit. Like, let's say me getting straight out of law school, I might not have all the resources yet, so I cannot take on a big case. That's me being still mentally unfit. But with time, 1 year, 2 year, a few years into my practice, I'm probably going to have much more experience where I can take bigger cases. But the lawyer has to, or let's say that the lawyer goes skiing and suddenly breaks a leg or breaks a hand and is not able to defend. So the lawyer has to be physically or mentally fit. And also, if the client ends a relationship, it's over, okay? And also, the next thing I would like to talk about is optional termination. So you can do optional termination when there's no material adverse effect or criminal or fraudulent acts. I don't know why I put that there because that's not optional for the lawyer. If someone's asking for criminal and fraudulent act, is termination. And finally, if the client fails to fulfill the obligation or if there's an unreasonable burden or some other good cause. Also, how do you terminate? You terminate by following the tribunal's rules. So in all cases, you must still reasonably protect the client's interest and give reasonable notice and surrender all the files and refund all the fees. So that's very important. So to summarize, I just talked about the scope and the authority, and finally, how to terminate an attorney-client relationship. I really hope you enjoy studying. Good luck.